Start para. Sir, I do not think it would be necessary for me to take much time of the House in order to command this measure to the honorable members. The main provisions of the bill are three. First, the bill seeks to give compensation to workmen who may become victims of war injuries. Second, the bill seeks to make employees liable for such compensation. And third, the bill seeks to compel employers to insure against liabilities imposed upon them. Now, taking the question of compensation, the point to which I wish to draw the attention of the House is that this bill is a linked measure. It is linked of Workmen's Compensation Act. Now, sir, the relationship of this bill to the War Injuries Ordinance to which I have made a reference is plain. As honorable members will recall, the War Injuries Ordinance defines that what is called the qualifying injuries. Those injuries are classified in that ordinance. What the present bill does is to adopt the scope and limits of the qualifying injuries as has been defined in the War Injuries Ordinance. As to the question of relationship of the present bill to the Workmen's Compensation Act, that will be clear to the honorable members from the fact that the amount of compensation which has been fixed in this bill for the victim of war injuries more or less follows the scale that has been fixed in the Workmen's Compensation Act. Now, sir, the reason for bringing this measure is this. After the War Injuries Ordinance was passed, a question was raised whether the payment made to a workman who unfortunately happened to sustain what is called the qualifying injuries should be sort of relief or should be compensation. The difference between relief and compensation is quite obvious. Relief is merely to help a person to get over the difficulties to which he might be reduced by reason of the incapacity which he suffers by a war injury and which prevents him from earning normal wages. On the other hand, compensation according to the terms of the Workmen's Compensation Act seeks to make payment which compensates him fully for the loss which he incurs. When this question was raised, a reference was made to the conditions that were prevailing in England, and it was found that the British Parliament passed an enactment which is known as the War Injuries Miscellaneous Act. On examination of the provisions of this law, it was found that the payments which were allowed under that act amounted to compensation and not merely relief. Obviously, the question arose whether it was not desirable for the Government of India to follow the principle which was laid down in this statute. Secondly, some of the employers on their own accord, after the passing of the War Injuries Ordinance, address a letter to the Government of India stating that from their point of view, the provisions made in the War Injuries Ordinance were not sufficient for the maintenance of the moral of labor and that compensation should be paid in order that the laborers working in disturbed areas may remain steady at that work. Stop.